Good morning. We'd like to call the Tuesday, June the 13th, 2023 Board of Funeral Directors and Embalmers, Tennessee meeting to order. Miss Lisa Bohannon, if you'll call the roll, please.
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Skill-Haynes. Chris Lee.
Here.
Scotty Porsche. Charles Rahm. Pam Stevens. Mr. President, we have a quorum.
Thank you, Ms. Bohannon. At this time, we will review and accept a motion to approve our agenda as presented.
So moved.
Second.
All right. I have a motion by Mr. Berry, second by Mr. Lee to accept our agenda. All in favor say aye. Aye. Any opposed? All right. We will move to the review of minutes. Give you a few moments to look that over if you haven't had time and bring up any changes that need to be made. If not, we'll take a motion.
Move they be approved.
Second.
All right. Motion by Mr. Berry to accept the minutes as presented. Second by Mr. Lee. Any other questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right. Good morning, Mr. Bryant. We'll turn to you for our legal report, sir.
Good morning, board members. The first complaint is complaint number 2023-023281. This complaint was administratively opened following an inspection conducted on May 9th, 2023. During the course of the inspection, the manager for respondent establishment had a funeral director and embalmer's license expire on March 31st, 2023, and was not renewed until April 5th, 2023. During the time of the invalid funeral director and embalmer's licenses from April 1st through April 4th, 2023, the manager of respondent establishment acted in the capacity of a licensed funeral director and funeral establishment manager for two decedents. Respondent replied, apologizing for the oversight and failing to renew their license in a timely manner. Respondent confirmed that they had received the email notification prior to the expiration of their license, but stated that they were missed because they were in the junk mail folder. Respondent further provided they mistakenly believed that they had another year
He is now joining
until their license expired. Respondent stated after speaking with someone in administration who confirmed that the license was expired, respondent attempted to renew the license on April 4th, 2023. However, respondent reported that the system was down and they were unable to pay that day. Respondent provided that the first thing the following morning, they successfully renewed their license on April 5th, 2023. Respondent again apologized for the mistake and stated that they had taken measures to ensure that the mistake does not happen again, including setting reminders to alert them before expiration date and updating their email to ensure that reminders were not sent to junk mail. Based on the above, we would recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Am I correct? That is consistent with what we've been doing in the past.
That is, yes. That's, I would say, a shorter time period of expiration than normal, but there were two license activities conducted essentially during that time.
Second. All right. We have a motion by Ms. Stevens to approve legal's recommendation of a $250 civil penalty. Second by Mr. Berry. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right. Number two.
Number two is 2023-023291, and essentially it is the exact same administratively open complaint from the previous one, with the difference being that this is the exact individual who had the expired registration rather than the establishment. So based on the above and all the information previously supplied, we'd recommend a letter of warning.
Do we approve council's recommendation?
Second.
Okay. Just a quick question there for me. Is there a reason why we're doing a letter of warning and not the same penalty?
Ordinarily, consistently, we've done an civil penalty assessed against the establishment and a letter of warning for the individual, assuming there isn't a large disciplinary history of this being a recurring issue, or if it was a exceptionally long period of time. Generally, this is just consistent with how we've approached these in the past.
All right, we had a motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation, letter of warning. Any further questions? If not, all in favor say aye.
Aye.
Any opposed? All right, number three.
Number three is number 2023-012921. Complainant, daughter of the deceased, alleged that after learning that the establishment which respondent was employed had possession of the decedent's remains on March 16, 2023, complainant informed the establishment she wished to have the remains transferred to a separate establishment. However, on March 17, 2023, the establishment called complainant and informed her that the POA still had authority and that they were not allowed to work they were only allowed to work with the POA regarding services and transfers. Respondent confirmed that complainant called on March 16, 2023, claiming to be next of kin and requested that the decedent be released to a separate establishment. Respondent stated that complainant did not provide any documentation of her relationship or authority to make funeral arrangements for the deceased. Respondent stated that their procedure to release a body from the establishment requires written documentation and authorization, and that complainant was informed that the body was released to the establishment by the power of attorney and that funeral arrangements were pending. As a result of this, on March 17, 2023, the granddaughter of the deceased emailed respondent the durable power of attorney document. The document named another individual named to be power of attorney, and in the event that this individual was unable to serve as POA, the decedent's granddaughter would be named POA. Specifically, the document was emailed to provide a clause on page 9 that specified that, quote, the durable power of attorney was given authorization to direct the disposition of decedent's, your remains, end quote. Again, the same day, complainant called the establishment stating she was next of kin and that she wanted the decedent's remains released from the establishment. The establishment advised complainant of the durable power of attorney document and pointed her to page 9 of the document, allowing for determination to be made regarding the disposition of the decedent's remains. Respondent attached to their response all legal documents regarding the power of attorney, including the notice of filing the durable power of attorney electronically filed on July 27, 2021, and the copy of the document titled, quote, durable power of attorney for financial affairs and health care, end quote. Legal further observed page 9 of the document, which states verbatim, quote, unless you otherwise specify in this document gives your agent the power after you die to, subsection 3, direct the disposition of your remains, end quote. Each page of the document is properly signed and notarized where appropriate. Based on the above, respondent abided by the wishes of the designated power of attorney, and while complainant asserts to be next of kin and the daughter of the decedent, 625703 states that an attorney in fact precedes children in the determination of priority of right to controlled disposition of remains and arrangements. Therefore, we would recommend closure.
Move that we accept council's recommendation for closure.
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation for closure, second by Ms. Stevens. Any further questions or discussion? If not, all in favor say aye. Any opposed? All right, number 4.
4 is complaint number 2023-008161. Complainant, sister of the deceased, alleged that respondent establishment was refusing to release the decedent to another funeral home. Respondent replied, stating on February 16, 2023, they received a call from a different sister of the decedent requesting that respondent establishment pick up the decedent from the hospital. Soon after, respondent establishment received a call from the hospital authorizing transportation of the decedent. Respondent stated that several days later, complainant, who over the phone purported to be the sister of the decedent as well, claiming that the person who gave respondent establishment permission to pick up the decedent was not actually related to the decedent. Respondent claims that they explained to the complainant that they relied upon reliance information provided by the family and explained the services that the other sister had picked out, and also provided that there was no insurance. Respondent stated they asked what funeral home that the complainant wished for the decedent to be transferred to and asked whether they had made contact with the new establishment. Complainant identified the new establishment and stated that they had not made contact with them at that time. Respondent contends that they quoted complainant their transfer fee and asked that complainant contact the new establishment to ensure that they are interested in receiving the transfer. Respondent further stated that they were familiar with the funeral director at the new establishment and asked that complainant tell them to give him, the funeral director at respondent establishment, a call. Respondent stated that they contacted the sister of the decedent that they had been working with and explained the situation. Respondent stated that the sister claimed that complainant was upset about the relationship between her and the deceased and that complainant and the decedent were not close. Respondent also stated that whatever complainant wanted to do was fine with her. Respondent then called the funeral director at the new establishment on February 21st, 2023, who, according to respondent, stated that he did not know complainant and had never spoken to her regarding a transfer. Respondent stated he explained the situation to the new funeral director, told him what the transfer fee was, and asked that he contact him when he heard anything. The new funeral director texted respondent on February 23rd, 2023, informing him that he had still not heard anything from complainant. Respondent called new funeral director on February 24th, 2023, and said that he would release the decedent to him based upon professional courtesy. The following morning, on February 24th, 2023, at 9 a.m., the decedent was transferred and signed for with the approval of the sister that respondent had been working with. Based on the above, a large portion of the complaint appears to be family matters and disagreement. Further, since the transfer of the decedent has been made as of February 24th, 2023, for point of reference, the complaint was filed February 23rd, 2023 at 3:30 p.m., and the initial pickup of the decedent was authorized by a sister of the decedent. Complainant has not provided any proof of violation of applicable laws or rules. Therefore, we would recommend closure.
Questions or discussion?
Notice he used the word transfer fee. You think he's referring to like transportation to relocate the deceased? Or?
I believe so, yes.
Okay.
I kind of read it as maybe the initial removal. I didn't.
I never.
Yeah, I didn't. Yeah, that's just. I guess what in my mind the direction it went was the initial removal that funeral home made.
I hadn't heard of a
Transfer fee.
a transfer fee. Move we approve council's recommendation for closure.
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation of closure, second by Mr. Lee. Any further questions? If not, everyone in favor say aye. Aye. Any opposed? All right, looks like 5, 6, and 7 are all together.
Yes, these are complaint numbers 2023-017331 for the funeral establishment, 2023-017351 for funeral director number 1, and 2023-017371 for funeral director number 2. On March 29th, 2023, an inspector with the department conducted a routine inspection of the respondent establishment. The inspector arrived at approximately 8:50 a.m. and arrived at the crematory at respondent establishment. Upon entering the facility, the inspector noted an employee working at the processing station with cremated remains in the catch pan at the retort. The investigator observed that the retort was heating and a decedent was sitting in front of the retort waiting to be cremated. The employee present at the retort was not a licensed funeral director, and no other licensed funeral director was present at the facility supervising the operation of the retort. Soon after, the inspector stated that respondent funeral director number 2 arrived at the crematory facility, who explained that he had not been supervising the employee at the retort and was away from the establishment because, quote, he had gone to get some gas, end quote, for his vehicle. Respondent funeral director number 1 is the manager of respondent establishment. Respondent funeral director 2 responded on behalf of respondent establishment and first acknowledged that the employee present at the crematory was not a licensed director, but stated that he was a licensed crematory operator. Respondent stated that right as the inspector arrived, the employee had, quote, just walked into the door of the crematory, end quote. Respondent claimed that the employee was not working the retort, but instead, quote, placed his hands over the cremains to see if they were still hot from the previous day, end quote. Respondent further contended that the inspector told the employee that, quote, he needed to see us place a deceased into the retort and would like to see us use our processor, end quote. Respondent stated that the employee took this request as permission for the employee to use the retort without a licensed funeral director present. Respondent stated that he arrived back at the facility after the prep work for the cremation had finished, and that both he and the employee, quote, proceeded to push the deceased into the retort, end quote. Respondent stated that he informed the inspector that he had been present at the establishment prior to his arrival, but that he had, quote, left to grab a beverage from the service station, end quote. Respondent funeral director number 1 supplied an identical response in response to the complaint. Based on the above, the employee present in the crematory conducted unlicensed activity without the required supervision of a licensed funeral director. Respondent funeral director number 2, based on the statement of the investigator, was supposed to be present for supervision during the process, but left the crematory while the employee was conducting licensed activity that required supervision. Respondent funeral director number 1, as the manager of record for the establishment, also maintains a responsibility of oversight for the establishment and a responsibility to oversee unlicensed activity. So based on the above, we would recommend a $1,000 civil penalty assessed against the funeral establishment, a $250 civil penalty assessed against funeral director number 1, the manager of the establishment, and a $500 civil penalty, I guess, assessed against funeral director number 2, who was supposed to be supervising the unlicensed employee. And we would recommend authorization via consent order and a formal hearing if necessary for all 3 of those complaints.
I guess first question would be, why is funeral director 2's penalty maybe not as high as it, in my opinion, should be? He or she was responsible, correct?
Correct. So essentially the reason for starting out at $500 is that funeral director 2 does not have the funeral director 2, the one in charge of supervising the employee, does not have any disciplinary history. But essentially that is the basis for starting at 500. If the board feels that that should be higher based on the facts that we have in front of us, then that's certainly their prerogative.
Just for future reference and for folks at home watching or may watch after the meeting's over, being a certified crematory operator, you still have to be a licensed funeral director to operate the retort in the crematory.
Essentially, you do have to be licensed to operate it or have a licensed individual supervising and observing you, which appears to be what had, I guess, was the intended mode of operation, which is totally permissible. But when you have the person who's supposed to be supervising step out, then that kind of severs the chain of
I want to be clear on this. There was not a human remains in the retort. Is that correct?
That's what I was reading, Miss Pam, that there was no processing actually going on and there was nobody actually being cremated. So I was kind of curious as to what violation, I guess, occurred at that moment.
So there were human cremains that had been there from the previous day. My understanding is that it walked in kind of first thing in the morning, and that the cremains of a decedent were in the retort that had been cremated the day before.
Was the individual that was in there that was non-licensed, were they doing anything of processing the human remains in the retort by what they refer to as removing the cremated remains from the actual retort once the cremation was completed the day before? So we're talking, it's a very gray area, in my opinion. But we're talking whether or not this unlicensed funeral director was doing an actual process for cremation. It is, again, I'll repeat, it is a gray area.
I do not want to misquote, so let me, if you guys do not mind, let me pull up real quick the exact inspection report from that. So here's what I have in the verbatim. in the inspection report. The work being done on arrival. The employee was working at the processing station. There were cremated remains at the processing station that the employee was working on when I arrived at the facility. There were cremated remains in the catch pan at the retort. The retort was heating. A deceased body was sitting in front of the retort, waiting to be cremated. Let's see. Then respondent funeral director number 2 arrived at the crematory facility. Respondent funeral director number 2 is a licensed funeral director that is employed by respondent establishment. That individual said he had been to get some gas. The employee loaded the deceased body into the retort for cremation. So at that point, the licensed individual is present. So the rule that gets pulled here is 0660-09-.01. It is requirements for a crematory is the title of that rule. Subsection 1 says no person, partnership, firm, association, or corporation shall conduct, maintain, manage, or operate a crematory facility unless a license as a funeral establishment or such license has been issued by the board. And let's see. Subsection 7B says all cremations of human remains in this state shall be directly supervised by a licensed funeral director during the cremation process, including but not limited to the placement of remains in cremation chamber, repositioning of remains, removal of cremated remains from the chamber, processing of cremated remains, and placement of cremated remains in an urn or other container. So I do think, Ms. Stevens, your point is very well taken, that kind of what, like you said, a gray area of, okay, where do you cross that invisible line? And I do think the rule is fairly encompassing of, again, from someone who does not know the business, so I'll defer to you all on that. My understanding of that rule is that it's fairly encompassing throughout the entirety of the cremation process. So from my understanding of the rule and from what our investigator or our inspector noted, I do think that crosses that line into that gray area of the employee was performing activity that he needed to either be licensed for or have someone licensed supervising. And it seems like there was that small window where the person who was supposed to be supervising him had stepped out, which would be a violation of that rule.
Repeat that rule number for us, please, for future reference.
Sure. It is 0660-09-.01. And that section that comes into play here specifically is subsection 7. And then there's an A and a B. And B is the one that lays out essentially what you can and cannot do.
I'm not questioning the process or the law. I don't have a complete understanding of where all the cremated remains were, and that if this individual was heating up the retort and an inspector is in the building and asks this person to place the body into the retort, I would do whatever the inspector told me to.
The way I'm seeing it, Miss Pam, and I agree with you 100%. I'm seeing a body, I guess, on the rollers, prepared to go into crematory. I see the previous cremation raked into the catch pan. I see the third on the processing table where the employee was standing, quote, seeing if it had cooled down for the next day. I can't pinpoint or see, I guess, what the employee was doing at that time that, I guess, violated that specific rule.
Simply because that employee was working in the cremation area by themselves? Is that what we're getting at?
I would say so. I think that, again, understanding that there are going to be some gaps in that. So, again, not to sound like a broken record, but to reread that, all cremations of remains in this state shall be directly supervised by licensed funeral director during the cremation process. So whatever the spectrum of cremation process is, including but not limited to placement of remains in a cremation chamber, the repositioning of cremains, removal of cremated remains from the chamber, processing of cremated remains, and the placement of cremated remains in an urn or other container. So that is a non-encompassing list that says including but not limited to. So there could be other things. If ultimately, if I guess in the board's view of that, based on what the inspector observed, if the board feels like that does not cross that line that Ms. Stevens pointed out of kind of that gray area of what is and is not considered the cremation process. One thing I will say is that, reading what the inspectors said in their report, I wasn't there. I can't say whether the inspector told that employee, we want to make sure your retort's working. Can you fire it up for me? I don't know. What I will say is respondent funeral director number 2 said that, but he also wasn't there. So presumably he's getting that information from the employee. So I have no idea on whether he did what he did because the inspector told him, if he really was just seeing if it was warm from yesterday. I'm not sure to the extent, but what we do know is that the inspector walked in, the employee was doing something with the retort, whether that crosses that line of cremation process or not, that's up to the board. And the person who was supposed to be supervising him wasn't there to supervise him. He did come back very shortly thereafter, but there was this gap in time where the establishment, at absolute best, opened themselves up to a position to where that line could be crossed because the person who should have been there had left the room for a short period of time.
I agree that the funeral director was off the premises and there was someone in the crematory. I do agree with that. And I agree with legal's recommendation. But before I move on with that, I would like to say to the Tennessee Funeral Directors Association or any other seminars that we can do to improve this process for people that are certified cemetery cremation operators in the state of Tennessee, we need to do a better job of educating. So with that said, I approve with legal's recommendation.
Do we need to take these one by one, or can we bundle them?
I would take them one by one just to be clear and just in case.
Ms. Stevens, if you'd like to start with the funeral establishment.
I'd like to make a motion to accept legal's recommendation for $1,000 civil penalty to the funeral establishment.
Second.
Okay. On the funeral establishment, we have a motion by Ms. Stevens for a $1,000 civil penalty authorizing via consent order and formal hearing if necessary, seconded by Mr. Berry. Any further questions on the establishment? If not, all in favor say aye.
Aye.
Any opposed?
No.
Let the record reflect that Mr. Lee voted no. All right. Move on to funeral director number 1.
For funeral director number 1, the $250 civil penalty, I'd make a motion we accept legal's opinion.
Second.
All right. So we have a motion by Ms. Stevens to accept legal's recommendation, $250 civil penalty authorizing via consent order and formal hearing if necessary, second by Mr. Berry. Any further questions on funeral director number 1? If not, all in favor say aye.
Aye.
Any opposed?
No.
Let the record reflect Mr. Lee voted no on funeral director number 1. And then we'll move to funeral director number 2.
Funeral director number 2, $500 civil penalty. My motion is to accept legal's recommendation.
Second.
All right, we have a motion by Ms. Stevens to accept legal's recommendation of a $500 civil penalty authorizing via consent order and formal hearing if necessary, second by Mr. Berry. Any further questions on funeral director number 2? If not, all in favor say aye. Aye.
Aye.
Any opposed? And let the record reflect Mr. Lee voted no on funeral director number 2. All right. All clear on this one before we move on.
I would just second what Pam was saying about the education, and crematories are popping up everywhere, lots of operators, and I just think you're going to have to be very careful, and you can't give any appearance that you're in violation or in the act of doing something. In this situation, he may not actually been caught doing one of those things, but it sure does give the appearance that the crematory was in operation without a licensed director there. So this one is tough, and it kind of sets a precedence. This is the first one of this matter that I've heard since I've been on the board, but I think we always try to take that in consideration when we hear future cases that involve similar items, that we try to be consistent. So it kind of does set a precedence here. So it's kind of a warning that crematories really need to be careful about the appearance of what they're doing and not having a licensed director there.
I agree, Mr. Berry. And in addition to that, I think there needs to be better language on what direct supervision is for crematories.
Other comments here? Moving on to number 8, please, sir.
Number 8 is complaint number 2023-021731. Complainant wife of the deceased alleged unprofessional conduct on behalf of respondent establishment. Specifically, complainant alleged that after her husband passed away on April 23, 2023, she was originally planning to use respondent establishment for their services. However, complainant decided to have her husband cremated, and she opted to use a different facility. Complainant stated that they told respondent establishment to not allow the decedent's mother to have any services for him, the decedent. Complainant alleged that respondent allowed the decedent's mother to use their facility for a memorial for the decedent and allegedly printed off obituaries with false information and, as complainant alleges, was written out of spite. Complainant also stated that the obituary was written by respondent establishment omitted her from the obituary. Respondent replied, confirming that the decedent had passed away on April 23, 2023, and that complainant had contacted respondent establishment informing them that she planned to use them to provide final services to her husband. However, respondent stated that they were never called by the medical examiner to pick up the decedent. The following day, complainant called and informed respondent establishment that they decided to use another establishment. Respondent stated that they were later contacted by the decedent's mother, who was inquiring if the decedent's body had arrived at their funeral home. Respondent informed the decedent's mother that the body had never been transferred to their establishment and they had never received the decedent. The decedent's mother was unaware of this change, apologized, and thanked them for their help. Later that day, complainant called respondent and asked if her husband's body was at the respondent establishment. Respondent reminded complainant that she had selected another establishment and that they had never received a call from the medical examiner, and therefore the decedent had never arrived at their establishment. The following day, the decedent's mother called respondent and inquired about renting their chapel for memorial service for the decedent, and after a meeting, secured the use of the chapel only. Respondent inquired as to whether the service was to be public or private, and decedent's mother informed them that it would be public. The memorial service was set for Wednesday, May 3rd, 2023, and the decedent's mother requested that an announcement of memorial service be posted to their website and the online newspaper. Respondent stated that the decedent's mother brought the information to be posted a few days later, and respondent submitted it to the website and paper as instructed. Later that day, complainant called respondent again, inquiring as to whether the decedent's body was going to be at the memorial service scheduled for May 3rd, 2023. Respondent again reminded complainant that she had chosen a different funeral home and they had never received possession of the decedent's body. Respondent stated at no time did complainant ever state that she did not want the decedent's mother to have a memorial service for the decedent. Based on the above, I would recommend a letter of warning.
I guess my question is, what was the violation on that?
Sure.
Yeah, 'cause that happens a lot. So, to just rent chapel for memorial service, or the wife wants to have one here and the mother or something wants to have, so.
So this is one that I will be upfront and honest just from the jump. I've struggled with this one a lot because this one seems so much in the vein of professional conduct and what is and isn't considered professional in the business. So I would implore you, even more than normal, which I'm normally very open to, if this is way off base, please let me know and feel free to do what all you think is best. So it gets tricky in that the statute for disposition of remains, which is for the definitions, so that would be 625701. So I don't think there's much argument that the daughter would be considered next of kin based on the information we have here. So right of disposition means the right to determine the disposition of the remains of a decedent, including the location, manner, and conditions of disposition and arrangements for funeral goods and services. So what gets tricky there is that this respondent establishment, it's undisputed, never had the remains of the decedent. So that kind of invites the question, is having the memorial service, I won't say a competing memorial service, but a separate one with the mother, a violation? And I think probably a strict reading of that definition, the answer would be no. But I think what the respondent kind of runs into that gets a little tricky, and I understand as well reliance information when someone brings you obituary information. I was actually able to find the obituary online, and it did not include the complainant who they had spoken with. I know it gets so tricky if there are so many family dynamics out there, and it's such a sensitive topic and such a sensitive time for a lot of people. But when they had a public service with a published obituary that had information that they could or could not have corroborated, I think that gets a little close. But again, I defer to you all and your experience on that.
I guess the way I see it, it was a cremation, which is final disposition. She rented the funeral home chapel, paid them to put a notice in the newspaper. She could have rented the park over here and put it, you know what I mean? I think once the complainant had final disposition, there's no violation there. I just don't see how you can.
That's what I was going to
turn down
ask. They did not
somebody-
have a contract
Yeah.
with the wife, correct?
Correct. They did not.
I mean, we've all had people walk in and want to rent a chapel and
Yeah.
put an obituary in. In my opinion, I won't speak for everybody else, I don't feel like this establishment's done anything wrong here. So would we be wrong to change it to closure by the rule that you've read?
I don't think you'd be wrong to change it to closure at all. I don't think there's anything in this definition of disposition, right of disposition, that they violated. I think the only thing it would go under would be those rules of professional conduct, which again, as I say, almost every meeting I defer to you all on that. So yeah, it's I think you can just make a motion for closure, and that would be totally fine.
President, I offer a motion of closure on this case instead of a letter of warning.
Second.
All right, we have a motion by Mr. Lee to change from a letter of warning to closure, and a second by Ms. Stevens. Any further questions here on this case? If not, all in favor of the change to closure, say aye.
Aye.
Aye. Any against? All right, number 9.
Next complaint is complaint number 2023-017591. Complainant alleged that respondent was knowingly advertising an office location that complainant did not have and a phone number that they do not own via a website that advertises all of these advertisement infractions. Respondent replied stating that the office location referenced by complainant had a name change that had been approved by the board, and upon that approval, also requested the host of the former website be replaced with a new website. All signage associated with the former name was removed as well. On January 11, 2023, respondent notified the board of the closing of that location, and a receipt was issued for surrender of that license. Following its closure, respondent contends that they followed state guidelines and removed signage and the websites. Respondent stated they were unaware of the previous host of the website referenced by respondent had not been taken down from online publication. Once respondent was made aware, it was immediately removed the same day. In actuality, the phone number that had been displayed was the correct phone number. However, it now went to the new location with a different name rather than the outdated name that had previously been advertised. Legal confirmed that the website linked in complainant's complaint was no longer active at the time of respondent's reply. So, based on the above, we would recommend a letter of warning.
There's no discussion. Motion to accept the letter.
Second.
All right, we have a motion by Mr. Lee to accept legal's recommendation of closure, second by Mr. Berry. Any further questions here?
Closure or letter of warning?
Letter warning.
Okay.
Second, I may have. If I did, sorry.
We got
We're
you.
going letter of warning. All in favor say aye.
Aye.
Any opposed? All right, number 10 and 11 are together.
So these are complaint numbers 2023-020951 for the funeral establishment and 2023-020551 for the funeral director. Complainant, through counsel, stated that on October 8, 2021, the decedent entered into a contract for prepaid services with the respondent establishment for $7,500. In the process, the decedent named respondent establishment as the beneficiary of a $2,500 life insurance policy and named respondent funeral director as the sole beneficiary of his $5,000 retiree life insurance policy. Complainant alleges that the form falsely represented that respondent funeral director was the decedent's cousin. On September 9, 2022, complainant stated that the decedent moved to Pennsylvania, and on September 24, 2022, decided that he wanted funeral services to be provided by an establishment in Pennsylvania. The decedent suffered a stroke on September 26, 2022, and complainant, the decedent's son, exercised their power of attorney over their father's affairs. Complainant stated that on October 28, 2022, they mailed the power of attorney notice to PepsiCo, and on November 14, 2022, PepsiCo purportedly advised complainant that the power of attorney had been approved and the beneficiary of the life insurance policy had been changed. Complainant stated that on November 18, 2022, they sent a letter to the respondent funeral establishment requesting the $2,500 policy be sent to the Pennsylvania establishment. Respondent funeral director responded to advise that the request be... The decedent passed away on November 25, 2022, and soon after, respondent funeral director received the $5,000 PepsiCo payment that complainant alleges should have gone to complainant or the Pennsylvania establishment. Complainant alleges that respondent funeral director has not responded to their communications, requesting that he return the funds that they allege were inappropriately received. Respondent establishment replied, confirming that the decedent did start a prearrangement on October 8, 2021, but stated that they were never the beneficiary of that policy. In actuality, respondent establishment owned an irrevocable assignment on that policy. Respondent stated that in November of 2022, they were contacted regarding those funds, and they informed complainant's counsel as to how to claim the funds. In December of 2022, respondent stated they were contacted by the insurance company to release the assignment of the policy, which respondent did. Respondent establishment stated that they were not involved with the $5,000 policy. They have never had an assignment, ownership, beneficiary status, etc. with PepsiCo, and that the only connection they have with that policy is that one of their employees, respondent funeral director, was named by the decedent as 100% beneficiary of the $5,000 PepsiCo policy on October 8, 2021. Respondent funeral director also responded, stating that on October 8, 2021, he met the decedent at his residence to discuss funeral arrangements and final wishes. Respondent contended that during the meeting, the decedent wanted to name respondent as beneficiary, being that he only had distant relatives in this area, of which respondent stated to be a cousin of his. Respondent stated that because they were related and due to the small number of relatives in Tennessee, he did not anticipate this being an issue. Respondent stated that the decedent's final wishes were to be buried in Tennessee with other family, and for respondent to take the funds from the PepsiCo policy and finish paying off the decedent's funeral services when he died. Respondent contended that it was decedent's concern that he would end back up in Pennsylvania and be cremated against his wishes. Respondent stated that the decedent instructed him that if this happens, he wished for the funds of the PepsiCo policy to be used to purchase a monument for he and his late wife to be installed at a cemetery in Tennessee, to pay for the repair of the decedent's father and mother's monument, and to donate the remaining funds to the cemetery for perpetual care. Respondent stated that they agreed to this. Respondent attached documentation to show that a monument had been ordered, and they are waiting on it to be delivered so that it may be installed at the cemetery. Respondent stated they have also received quotes on fixing the other monuments, and that whatever is left will be donated to the cemetery per decedent's wishes. Respondent also attached a screenshot conversation between he and another relative of the decedent dated on October 16, 2022, discussing the final wishes of the decedent. In these messages, the family member of the decedent also expressed that the decedent asked to speak to respondent regarding his final wishes. Finally, respondent stated that after decedent's death, PepsiCo notified him that he was the named beneficiary of the policy and sent him claim forms to process. Respondent attached these documents to their response. In a rebuttal email dated May 3, 2023 at 9:50 a.m., complainant alleges that respondent funeral establishment allowed respondent funeral director to act as their agent and, quote, through fraudulent means improperly obtained $5,000, end quote. Complainant continued that, quote, respondent establishment gave respondent funeral director its explicit approval or, by retaining his services and defending his actions, tacit approval to act in this manner. So respondent establishment is culpable of respondent funeral director's actions, end quote. However, in a later email dated the same day at 12:25 p.m., complainant states, quote, I'd like to clarify that although it is possible that respondent funeral director acted with respondent establishment's prior knowledge, he, respondent funeral director, had the proceeds sent to what appears to be his personal address, suggesting he was acting without respondent funeral establishment's knowledge, end quote. In a follow-up with respondent funeral director, legal obtained a document showing an estimate for the marker repairs and referred back to his original response regarding an invoice for the marker. Respondent stated that whenever the marker and repairs had been fully paid for, he would donate the remaining funds to the cemetery that decedent had named per their wishes. Based on the above, respondent establishment agreed and assisted with necessary documents for the funds to be paid to the successor funeral establishment in Pennsylvania. Therefore, respondent establishment has not committed any violation of applicable rules or statutes. Further, respondent funeral director appears to have abided by the wishes of the decedent. If, as complainant contends, PepsiCo acknowledged the change of the beneficiary from respondent to complainant, it was erroneous not on respondent funeral director, but on PepsiCo to supply the funds to respondent funeral director. From respondent funeral director's perspective, he received the $5,000 policy to be used as per the decedent's wishes, as purportedly discussed with the decedent on October 8, 2021. Complainant has not carried their burden to show a violation of applicable rules and statutes on behalf of respondent funeral director, as respondent appears to be carrying out the wishes of the decedent to the best of his ability. Based on that, we would recommend closure for both complaints against the funeral establishment and the funeral director.
Any questions for legal?
Can you clarify that last paragraph on page 10? Based on the above, respondent establishment agreed and assisted with necessary documents for the funds to be paid to the successor funeral establishment.
So basically, there was the entire pot here was $7,500. $5,000 went to the individual funeral director, and $2,500 was an assignment to the establishment. So both parties seem to agree. Even the complainant and the rebuttals acknowledged they had received the $2,500 that had originally been assigned to the establishment that they released and relinquished and had it sent up there to Pennsylvania.
I may be reading this one actual pre-need or just a life insurance policy that he made the respondent, I guess. Part of me is seeing a funeral home making itself a beneficiary on a pre-need. And I just want to make sure, I guess that's not the case.
Well, asking arrangement involved, and I guess nothing that we have suggests that it was.
No.
It was just dealing with those insurance policies.
So it was just an insurance policy, and he trusted this gentleman to be the beneficiary and carry out his wishes, I guess.
Correct.
Okay. I know when writing a pre-need, it's frowned upon that the funeral home is a beneficiary on an actual funded pre-need. That's one.
My understanding, the intent is that you want to make sure that that policy is freeable, transferable. So if it's assigned, whether it's revocable or irrevocable, you can transfer it. But if it's if a funeral home was the beneficiary, they could lock that down and not transfer it. So then the question is, okay, what about an employee of the funeral home? Does that get around that intent? And was the individual a cousin, or was that
That's
never
no way.
established?
So I know complainant put the burden on the respondent multiple times to name a common ancestor to show relation. I would say that as the complainant, that's on them to show that does not exist, rather than on the respondent to show that it does. No information was ever provided, but I do think the text messages with a relative of the decedent saying that, like thanking him for what he was doing and saying, hey, he wants to talk to you about, some kind of last wishes. Don't know if they're blood related. We don't have information to say that. I'll leave it at that.
For the recommendation.
Need to take these one by one, or can we put these together since it's the same?
I think you can take them together if they're the same.
I'll make a motion to accept council's recommendation for closure of both file numbers.
Second.
All right. Have a motion by Mr. Berry to accept legal's recommendation of closure on funeral establishment and closure on funeral director. Second by Mr. Lee. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? All right. Moving on to number 12.
Next complaint is complaint number 2023-023521. Complainant stated that their father passed away unexpectedly on March 6, 2023, and that they nor anyone else in their family were notified until 16 hours after the fact. Complainant said that a friend of theirs called them to inform them that an obituary had been written that was completely false and was told that an individual had given the funeral home the information. Complainant stated that this individual informed respondent that she was the wife of the decedent, which complainant contends is untrue. Further, complainant stated that in the obituary, no one's names were spelled correctly. Complainant stated that respondent told them that the individual respondent worked with told him that the decedent's children were estranged, which again, complainant contends is not true. Complainant stated they asked respondent to correct the errors in the obituary, which complainant stated that respondent did. Complainant also stated that on the day of the service, they asked respondent whether the decedent had been cremated already. Complainant contends that respondent replied yes, and then later told complainant that he was wrong and that the decedent had not yet been cremated. Finally, complainant stated that respondent, quote, allowed someone that said she was decedent's wife to, end quote, make decisions and determinations as to the services. Respondent replied, stating that the individual who he had worked with came into the funeral establishment purporting to be the wife of the decedent and wanted to make funeral arrangements. Respondent said that the papers they received stated that she was the decedent's wife. Respondent stated he met with the individual and had no reason to doubt the information she was giving him. When respondent questioned the individual about any relatives, the individual informed him that the decedent had an estranged daughter who he had not seen for quite some time. Again, respondent took this information as true. Respondent stated that the names in the obituary and their spelling were what were given by the individual, which again, they believed to be true. Respondent said that upon receiving a call from complainant and identifying herself, he made changes to the obituary and received approval from complainant on the changes. On the day of the service, complainant asked respondent if she could have some of the decedent's ashes. Respondent stated that she could, and that it had already been arranged by the individual who purported to be the wife of the decedent, who had purchased complainant and her family several small companion urns and jewelry with ashes in them. Respondent explained that, to their knowledge, complainant was all right with this. However, when respondent spoke to the directors to determine when the urns would be ready, they informed him that the physician had not signed off at that time. Respondent stated that they do not cremate until all forms are signed, and after relaying and explaining that the decedent had not yet been cremated, but offered that after the service they could make arrangements for complainant to view the deceased if she chose to do so. As respondent contends, complainant denied this request. Respondent stated that they apologized to complainant and accommodated complainant's wishes as best they could, given the information they received. Based on the above, we would recommend a letter of warning. And I will clarify. I saw Mr. Lee getting ready to ask a question. So I do think as far as the reliance information of receiving documentation that showed that individual they worked with was the decedent's wife, what information was put in the obituary, I don't see that as a violation. I think they went at reliance information, and then when they learned that that information maybe was not entirely accurate, they fixed it, and complainant agrees with that. I think for me, where the letter of warning comes in the violation of professional conduct is, I think that is a reasonable mistake to make of, your father, the decedent, has been cremated. Actually, I realize we don't have all the paperwork in. It hasn't happened yet. I'm sorry. Mistakes do happen, but that is a very sensitive mistake to make. And I think just a little bit of caution and carefulness on that professional side of it, just to, say, let me make sure, or as opposed to giving a, yes, he has been cremated. Actually, he has not. The paperwork's not done yet. To me, that was where it did kind of barely tip over the toe of professional conduct. But again, as always, I deferred to you all on that.
I'm glad you brought that up because I was going to hit on that. I agree with you.
Answer my question ahead of time. Good.
Learning us pretty well. Other questions?
One of the things that is not typical is during an arrangement that a wife shows proof of documentation they are a wife. Was that questioned in the beginning, that she wasn't the wife?
From what respondents said, when he got that documentation, he had no reason to question it. I don't know if she brought it anticipating that there might be a question, or
Okay.
I'm not sure. It was never explained why she had that on hand or
Okay.
pulled it or anything.
That's not typical. Do you all agree with that?
I agree. There's probably a lot of preemptive that she was preparing for the worst, probably when she come in.
And then again, we deal with that once or twice a week with that situation.
Other questions?
I'll take a motion, letter of warning, recommended by.
All right. I have a motion by Mr. Lee to accept legal's recommendation, letter of warning. Second by Mr. Berry. Any further questions or discussion? Not all in favor say aye.
Aye.
Any opposed? All right. We're moving to number 13.
All right, so this is a represent. This is complaint number 2023-011-841. This matter was previously presented to the board at its April 11th, 2023 meeting as follows. Complainant, daughter of the deceased, alleged that respondent establishment released the ashes of the deceased to a person who is not next of kin. Respondent stated that upon receiving the call for removal, he received approval and contracted with the sister of the deceased. Respondent continued that the sister contracted with them regarding a cremation, and that throughout the arrangement process he met with the sister of the decedent. Respondent stated that the services were carried out on March 1st, 2023, and that complainant called on March 9th, 2023. The manager was not at the office at that time of the call, so the call service requested that complainant call back the next day. The manager stated after being made aware of the complainant's call, he called the sister of the decedent, who requested that respondent not release the remains to the complainant and that she would send a representative to pick up the remains. Respondent stated that the sister provided that there was a lot of contention within the family and that she was following the wishes of the decedent. Respondent stated the cremains were picked up by the representative of the decedent's sister and attached a form to show that the cremains had been released to the stated representative. The sister of the decedent also provided a written statement corroborating respondent's version of the events. The sister specifically mentioned a difficult family dynamic and stated that respondent establishment did not contribute to that difficult dynamic. Further, the sister reaffirmed that she had made the arrangements with respondent and that she had directly contracted with them, and requested that the remains not be released to anyone but her or her representative. The bulk of the complaint appeared to be a family matter and issues involving next of kin determination. Based on the above, legal would suggest closure with any remaining issues of next of kin determination to be determined by a court of competent jurisdiction. The board asked that we receive additional documentation, specifically the cremation authorization form and any other documentation supporting how the decision was made and determination of the sister as next of kin. Respondent provided a copy of the cremation authorization form for the decedent. The form did not denote any specific manner in which the next of kin was determined or decided, as some stock forms do. However, legal also contacted the sister of the decedent. The sister explained that at the time of the decedent's passing, respondent did inquire as to whether there were other potential next of kin, a power of attorney, surviving spouse, children, etc. The sister stated that she informed them that there were children, but that due to their lack of financial resources and difficulty with the situation, they had determined that she, the sister, should handle the arrangements for the decedent and be denoted next of kin for purposes of the right of disposition. The sister further explained that during a private viewing, she inquired of all the children and family members, including complainant, as to whether they were satisfied with the service. The sister stated that at that time, everyone communicated that they were. Soon after, however, the sister stated that complainant and another family member had disagreements regarding the service. The sister stated that this family dispute and family matter evolved into further issues when complainant called respondent on March 9, 2023, requesting the cremains. Since respondent had been dealing with the sister directly, he contacted her to ascertain as to how he should proceed. The sister stated that she asked that respondent not release the remains to anyone but her or her representative so that the remains could be dispersed once the family matter had been sorted out. The sister spoke very positively about respondent establishment and again reiterated that this was strictly a family issue that had been blown out of proportion to involve respondent. Legal also spoke to complainant, who did not deny that the sister had been made next of kin and made the arrangements for the decedent. Complainant primarily objected to the fact that she could not pick up the cremains despite being the daughter of the decedent, and that a representative of the sister, not the sister herself, had been allowed to pick up the cremains instead of her. Based on the above, with the information we have, respondent appears to have made the appropriate inquiry into determining next of kin. Further, after respondent began working with the sister as a designated next of kin, complainant requests the cremains in opposition to the request of the sister. Respondent contacted sister to determine how she would like to proceed, and respondent followed the wishes of her sister. However, it appears that respondent did not directly corroborate complainant's surrender of next of kin determination with the complainant and took the word of the sister. While this could be considered reliance information and not a violation under the statute, reliance information ordinarily is applied when determining the existence of other potential next of kins, not their willingness to participate. When a respondent knew or should have known that a potential next of kin existed that preceded the sister in the order of the statute, respondent should have corroborated the complainant's willingness to relinquish next of kin determination. So one thing I will say in regards to this recommendation, I do think it's very tricky. What I think, and something I will also make clear, is that I think that is up to potential interpretation of the rule and statute. I kind of did the best I had with what I had in front of me with the information we had and my interpretation of how reliance information ordinarily goes. So what I suggested in the recommendation, since I do see why maybe your average funeral establishment or funeral director maybe wouldn't have known to do that their duty required reliance information to not go that far, is a letter of instruction regarding next of kin determinations. But if the board feels that essentially, I feel like this has 1 foot in letter of instruction territory and 1 foot in letter of warning territory. If you feel it's a bigger foot in letter of warning territory, then that is perfectly fine as well. But also happy to answer any questions.
With the documents that they presented, was there any legal forms where those children signed their rights over to the sister, or was it all by word of mouth?
There was not, from my understanding, and I asked for any other documentation that showed next of kin determination, the process they went through, and they only provided that documentation, the cremation authorization. I didn't see anything in that form where the children had to sign off and formally in writing relinquish their next of kin determination.
Children did not sign the cremation authorization.
They did not. The sister did. Okay.
During your follow-up with complainant, she did admit that the sister was made legal next of kin.
Yes.
I try, if we have a situation like that, I give them my number, have them send an email, and I know not required, but an email or a text message, I have it printed out and put it. Just can't be too careful about it.
Mr. Bryant, would it be possible for a letter of instruction regarding next of kin determination and also a letter of warning combined?
Sure. I don't see any reason why we couldn't do that.
I'd like to make a motion that we take legal's recommendation of letter of instruction regarding next of kin determination and add additional information, letter of warning.
Second.
All right. Have a motion by Ms. Stevens to accept legal's recommendation, letter of instruction regarding next of kin determination with an additional add of a letter of warning be added. And that was second by Mr. Berry. Any further questions or discussion here? If not, all in favor say aye.
Aye.
Any opposed? All right. Move on to number 14.
And the last one is another represent for complaint number 2023-004001. It was originally presented as complainant alleged unprofessional conduct on behalf of respondent funeral director. Specifically, complainant stated that the establishment that respondent works for completed the celebration of life for the decedent on November 28, 2022, and that following the ceremony, decedent was to be cremated. Complainant alleged that they had spoken to respondent numerous times regarding the cremation, and that he stated he was waiting on necessary papers to perform the cremation. Complainant stated that as of January 29, 2023, the decedent had yet to be cremated. Respondent replied stating that they had made numerous attempts to have the cremation approval form signed by several doctors. Respondent detailed how, since the decedent did not have a primary care physician, they had reached out to several doctors every week to try and have them sign the cremation approval form. Respondent stated after several doctors and numerous delays, they finally found someone who agreed to sign off on the permit on January 30th, 2023. Respondent stated that the decedent was cremated on February 2nd, 2023, and the cremains were picked up the following day, first by the respondent and then by the family. Respondent stated that they informed complainant throughout the process that they would not be able to sign the document since they were not a healthcare professional, and they would have to wait on physician's signature before proceeding. Respondent attached the cremation approval form to show that approval had been granted January 30th, 2023, the cremation permit to show that it had been signed on February 2nd, 2023, and the family accountability form to show that the cremains had been picked up on February 3rd, 2023. Finally, respondent attached communications to show that he had been in contact with the medical examiner's office to try and get the cremation approved as expeditiously as possible. I'd recommend closure, and then the board decided on a $250 civil penalty and a letter of instruction. So the update is that through counsel, respondent provided an update with additional documentation and explanation. Respondent provided the following timeline regarding the decedent and respondent's attempts to obtain a cremation permit. November 14th, 2022, the decedent passes away. November 16th, the decedent's family make arrangements with respondent. Respondent explains to the family, including complainant, the process of obtaining a cremation permit, which required approval and permission from the doctors, medical examiner, and the health department. November 28th, a celebration of life memorial services was conducted for the decedent. Also on November 28th, respondent included a physician who had attended to the decedent prior to their passing in the VRISM system for signage of the death certificate and cremation permit. Respondent attached documentation confirming that the stated doctor had been assigned the decedent's certificate in VRISM. December 22nd, 2022, after several weeks of discussion with the doctor's assistant, respondent was advised that the doctor nor the hospital would sign the cremation approval form. Respondent attached documentation to show that they had written down dates of the discussion with the doctor and the assistant. On January 3rd, 2023, respondent was advised by complainant that another doctor had been decedent's heart doctor and might be willing to sign the form. Respondent contacted the heart doctor's office, and after a few conversations, was advised that the heart doctor would not sign the cremation approval form. Respondent attached notes dated January 3rd, 2023, detailing the nature of the conversation and text messages from complainant. On or about early to mid-January, respondent contacted investigators at the medical examiner's office to try and obtain the medical examiner's signature for the cremation approval form. Respondent was eventually advised that the medical examiner would require either a death certificate signed by a physician, which respondent had had difficulty obtaining, or a statement of death from a treating doctor in order for the medical examiner to sign the cremation form. Respondent attached copies of emails confirming that this conversation occurred. On January 18th, 2023, respondent was advised by a family member of the decedent about a doctor that had been the decedent's primary care physician in the past. The decedent had not been to this physician in some time. On the 19th, respondent adds decedent's former primary care physician to the VRISM system, and respondent attached documentation to show this had been done. Soon after January 19th, respondent was advised that the former primary care physician would not sign the cremation permit. As a result, respondent again contacted the medical examiner and explained that they had exhausted all options. Employees at the medical examiner agreed to do a chart review. On January 30th, following the chart review, the cremation approval form was signed. A cremation permit was issued by the Department of Health on January 30th, 2023. Respondent attached copies of the signed cremation approval form and signed cremation permit dated January 30th, 2023. February 2nd, after the cremation permit was signed, the decedent was cremated. February 3rd, 2023, the family picks up the cremains from the respondent. Respondent further stated that they had communicated with either complainant and or other members of the decedent's family on a weekly or biweekly basis, depending on availability of updates. Additionally, respondent provided that in the county they conduct business in, the medical examiner does not and will not ordinarily issue a cremation approval without being provided a copy of the death certificate or a statement of the cause of death from a treating doctor. Respondent attached text messages and emails from the medical examiner's office supporting that assertion. In totality, respondent stated that while the cremation was ultimately delayed roughly 60 days after the celebration of life of service, respondent exhausted every effort to try and obtain the necessary documentation to try and receive the cremation permit. While respondent encountered these delays, he kept consistent communication with the decedent's family and apprised them of the difficulties and updates as they occurred. Ultimately, the complaint was submitted 1 day prior to the receipt of the cremation permit. Based on the above, respondent made reasonable effort to try and obtain the necessary documentation in order to cremate the decedent. Respondent attached sufficient documentation to corroborate their attempts to receive authorization. Therefore, based on the above, we would recommend closure.
If I'm reading this correctly, they waited over a month before the first contact with the medical examiner. Am I looking at that right?
Let's see. I believe so. They didn't include information if they had reached out to medical examiner prior. I think that, and one thing I will say, I'm not entirely sure of the entire process on everyone's end on that, but my impression was that they, that first stretch, they had assigned the doctor in VRASM system, and we're assuming that he would sign off on it. It'd be fine. It wouldn't be a problem. That's what I gather from what they provided.
It's just like they weren't very proactive. Maybe I'm looking at this wrong. Y'all can give your opinion, but typically if we can't get a doctor to sign, then we start reaching out to either the state verism system asking for help, or I've even gone to the medical examiner to try to push the issue. But to me, they waited over a month, so there wasn't a lot of proactive on their part, in my opinion.
I can definitely see that. One thing I will say that was clear to me, and not only reading what they provided but speaking to their attorney, is that it was a frustrating situation of they assigned that first doctor the same day as the celebration of life in the VRASM system, and it was okay, yeah, we'll get to it, we'll sign it, it's okay. And then it'd be a week, you'd reach out and say, we have any updates, can you sign this please, we need to get the cremation going. And it was just kind of I'll talk to the doctor and get back with you. That the 4 months was kind of they were strung along, so to speak, and just they were given the impression that the doctor would sign it and it'd be fine, until they were finally just given we're not going to sign that, after about almost 4 weeks had passed at that point.
I guess then another question would be, why did they wait 2 weeks from the date of passing to the date of celebration to assign it? If I'm looking at that right, is that not correct?
Probably just trying to determine what doctor to put in verism.
Out of that, or at least I do. State law requires a doctor to either sign off or reject with reason within 48 hours. I mean, we all know that doesn't happen. But I can't believe, having very firsthand knowledge with medical examiner duties in the office, that they wouldn't have done a chart review way before 60 days. Then again, you said there was corroboration through emails from the medical examiner investigators. So,
one thing I will say is that I think, generally speaking, I would say if you told me the facts of this, I would probably come to the conclusion, very similar to Mr. Harris, that 60 days is too long, and there was some way for you to be more proactive. what I think is different here is that they've basically the analogy they use in law school is that it's like a tennis match. The complainant hits it, the respondent hits it back, it gets hit back. I think with this, they've showed their work of I tried. That it was shouldn't have been this difficult, but it was, and I'm sorry. And I think it would be another thing. It would be a big violation if it had been radio silence with the family for 60 days. And I think it's clear that also didn't happen, especially when the family is giving him advice of, she saw this heart doctor, it's 8 years ago.
Yeah, they were giving him doctors to try
Yep.
as well.
So it's clear they were updated and involved in the process. So what I will say that if I think if the board still has reservations about maybe the overall proactivity of it, I would be okay with a letter of warning. I just think as far as a civil penalty with the amount of work shown, it gets difficult to point to a specific, this is where you messed up, here's your violation.
I agree with what you just said. It's just like they weren't as proactive as I would like to have seen, but that's my opinion.
That's a difficult one, but I'm going to make a motion for closure.
I'm going to second that.
All right, I have a motion by Mr. Berry to accept legal's recommendation of closure, a second by Mr. Lee. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? That would be aye. All right, anything else from you, Mr. Bryant?
That concludes the legal report, and you all were almost in for a treat today. We were going to give our Sunshine Laws just refresher presentation, but I've heard that there will be more board members present next month, so we'll just save it for then. So you all have that to look forward to.
All right. Thank you very much. All right, we'll move on to Mr. Gribble and the Executive Director's Report.
Good morning, board member. As the Board of Licenses administratively approved the Executive Director pursuant to Board authority for the period of April 8, 2023 through June 9, 2023, and you have a list of those that have been approved. And I think it's worth noting each time that there are approvals by reciprocity and some occasionally by reapplication, but we get asked from time to time about does Tennessee accept reciprocity, and as you see these approvals each month, you see that there are times that they do obtain. Closed establishment report. There's one establishment reported closing since the last board meeting. It's Smith Family Funeral and Cremation Services, LLC, which was located at 1939 Almaville Road in Smyrna, Tennessee. The reaction report. The report of consent orders have been administratively accepted and approved by the Executive Director pursuant to Board authority and as reported on the March 2023 and April 2023 Regulatory Board disciplinary action reports. And you have a list of those as well in the action. Complaint report. Ms. Bohannon tells me as of June 8, 2023, we had 9 complaints against funeral directors and embalmers, 13 against establishments, for a total of 22 complaints. And President, that's my answer.
Any questions for Mr. Gribble?
Move we accept the director's report.
Second.
All right, I have a motion by Mr. Berry, a second by Mr. Lee to accept Mr. Gribble's Executive Director report. All in favor say aye. Aye. Any opposed? All right. To my knowledge, we do not have any individuals or establishments. Is that correct, Mr. Gribble? All right. We'll move on to new business. And Mr. Bryant, I assume then the Sunshine Law, we're going to bypass you on that.
That is correct, yes.
All right. Then we'll move to the next item there. Mr. Gribble will let you give us an update on our new member appointee.
As they used to say when they were printing papers, it's hot off the press. so we do have an appointment from West Tennessee to replace Mr. Rahm. It's Mr. Wendell Naylor, who is a funeral director and embalmer from Memphis, Tennessee. So Mr. Naylor is the replacement for Mr. Rom, and Mr. Naylor should be hopefully at the next.
All right. Welcome him to join us. And for the record, we appreciate Mr. Rom's service to this board as well. The next item we'll talk about is moving of the July meeting to the 18th. There is a meeting the next day for this board. And so I have personally asked if there's no reservations so that I can make one trip. I do need to be present with Mr. Gribble for that meeting. If we could move it a week later, does anybody have any reservation or concern about that?
Mr. President, can
yes.
I explain just a little bit more
Yes,
about
please do.
different things too? There's also a secondary reason to move that meeting as well. Renovations, we've been talking about renovations to conference room 1A, which is the other room, and this room 1B. So we've been told that the renovations will occur from July 24 through August 14. We believe that to be correct. Now, we've been given some possible dates before, but this seems to be pretty focused and determined that that's when it's going to be. And then these rooms will reopen on August the 15th as a plan with the current audio-visual equipment. But then they'll be closed again in October is the expected date. And again, I say expected date for the replacement of the AV equipment. In October, if that occurs, that's expected to take a week then. So also, as Mr. Harris mentioned, the Board of Funeral Directors and Embalmers comes up for a sunset hearing before the Joint Government Operations Committee in House Hearing Room number 1 at the Cordell Hull Building on July the 19th at 9 a.m. And there's some other regulatory boards that are scheduled to be there at the same time. But a sunset hearing, every so often, each regulatory board, and it's my understanding, it's required to be every 8 years, but most of the time, the boards do not get an 8-year life when they go before the Joint Government Operations Committee. So whatever period of time they give you, then you're up for another sunset hearing when that period of time lapses. So our board is scheduled to sunset, so there's a hearing before the board, and there's several questions that we answer and supply to them prior to the meeting, and then that's a meeting that the board president is typically asked to be at, and if the board president cannot be present, then either the vice president or another board member. But if the board was in agreement to move the July meeting to the 18th instead of not have it on the 11th as previously scheduled, then that would not only accommodate Mr. Harris, but it would provide to have the July meeting a week later to include any applications that we might have that would need to be heard for the board, and then possibly, depending always in consultation with legal and the board president, might be that the August board meeting, that might be a good one to cancel, since the board cancels 3 or 4 meetings a year. Now we do have alternate places that the board can meet, and we can if we do need to meet in August, that can be accommodated there at alternate places. But if there's not a business need to meet, then August might be a good meeting to cancel and not.
The July meeting be also, if we don't have many agenda items, I wonder about the July. I mean, you don't know now, but what if we have very little business in July?
I do know for a fact that I won't be able to make, if we change it, I'll let Mr. Gribble and them know in the email, but I cannot be here the week after the 14th. Just make sure y'all have
I've got a conflict too.
Stevens, are you good?
Good.
Heard from the other 2 that we normally have with us.
And they saw the agenda, but I've not we've not received any communication back from them.
And I'm willing to do 2 weeks in a row if that's what we need to do. It was just going to be easier to make one trip, but I'm happy to do whatever.
Does that decision have to be made by?
Well,
We have to
be
give
good to
it.
make it today.
I was going to say, don't we
because-
have to post a 30-day?
Well, we don't necessarily have to post it 30 days in advance. It has to be well noticed. It could possibly, but with a new board member coming on, there'll be an orientation for that board member, so we need to schedule that for the. It's usually scheduled 1 hour prior to the board meeting, so we need to schedule that. Have this conference room by 11. So whatever the board decides to do. The reason I say it needs to be made today, it's hard. You know, everything has to be done in open meeting, so it's hard to make unless you leave the decision making to the president. Then it's hard to.
I want you guys to do, of course, what's best interest in everyone, but now we know two's not going to be here. I guess if everybody else will, but you
Can
don't
I ask
know
it
that.
this way? Can we tentatively let you email those two just to see? Is that doable? And if not, then we just stay with our regular date, or can we not do that?
I'm hesitant to conduct board business.
Okay.
I think yours are legal counsel, but if it's done in the open under discussion of the board and determination of the board, then there's no, I can't say that they did not email back me or Miss Bohannon and say that they couldn't be here, but neither did they respond and say they would, which I don't think they would have responded in the affirmative to us that they would be here.
If we're losing two for that meeting, but possibly having three additional, we would have a quorum for the July 18th meeting.
Take
There's no objection. I'm going to ask that we stick with that 18th unless somebody is totally against that, but anybody be okay with that or not okay? Because we know there's two and we're getting a new one. Ms. Stevens and I both could be here. Looks like we could have a quorum. Thoughts or feelings?
I can do the 11th or the 18th.
I'd say it's just risky with two board members not being able to attend. That's why I was asking about, but you don't know that either about the likelihood of agenda being heavy for July, that it's not postponed.
Typically, we would not miss. We did during COVID one time. We missed 2 consecutive meetings, but typically we would not miss two consecutive meetings because of the legal report.
Not saying July versus August, so it wouldn't be 2 consecutive.
In August, we could do it in August. We could do that, but we would need to use an alternative meeting spot. If that sticks to the schedule, and it looks like as late as last Thursday, it looked like it was pretty affirmative that it was going to stick to that schedule for the renovation. But again, we can go to alternative sites.
Oh, you're going to have one, I guess, board member, so that's 3. So you just have to have one more, right? Right. Yeah, I think that's right.
Nice.
There's no objection against me. I'm going to make the motion that we move the July meeting to the 18th.
I'll second.
Any other new business that we need to talk about?
You don't vote on it. You need to vote on it.
Oh, vote on the date change? Okay, yep.
Got a tie.
All right, all in favor of the moving of the date change, say aye. Any opposed? All right. Let the record reflect. We will meet in July on the 18th instead of the 11th. And before we do ask for adjourn, of
Is now
course,
exiting.
publicly, we will ask if there's any comments from the public. All right. If none, I will hear for a motion to adjourn.
So move.
All right. At 11:30, a motion by Mr. Berry, second by Mr. Lee to adjourn. All in favor, say aye.
Aye.
And we are adjourned.